All right, looks like we are live. I will go ahead and announce then this is the Kansas Court of Appeals hearing oral argument. We have one case on our docket today. It's First Security Bank versus Buehne. Let me introduce myself. I'm Gordon Atchison. I'm a member of the Court of Appeals. I'll be the presiding judge. Also sitting with me today are my two colleagues from the Court of Appeals, Judge David Bruns and Judge Tony Powell. Obviously, we're doing this remotely. This is the only case we have on the docket. It is set for a standard 15 minutes of oral argument. Mr. Schultz is the representative of the appellant. If you wish to reserve a portion of your 15 minutes for rebuttal, let me know at the start of your argument. We'll go ahead and do that. I will remind counsel that we have read the briefs and are generally familiar with the facts of the case. Not my business to tell you how to argue your cause, but you might want to just jump into the salient legal issues rather than give us a long rendition of the history of the case. With that, I'll call First Security Bank versus David Buehne and Lindsay Buehne. Mr. Schultz, you have the floor.
Thank you, Your Honor, and may it please the court. I'm Zachary Schultz from Garden City, and I'm representing the appellant and defendant in this matter, David and Lindsay Buehne. I would like to reserve 3 minutes for rebuttal.
Please proceed.
We are here today because the bank waited 8 years to file suit after they had the clear right to file suit to foreclose this note and mortgage. The bank made a demand for payment on a payable on demand note in 2006. The bank waited until 2014 to file suit, and in doing so, allowed the 5-year statute of limitations to expire. If you look at this case and assume that the bank had filed suit in September of 2006, this court would not entertain the notion that the bank had failed to comply with the terms of the note or any of the notice provisions, or that it did not have the right in 2006 to file suit. It is important to remember that these loan documents are merely contracts, and the job of the court is to enforce contracts according to their terms. Not all mortgages and not all promissory notes contain similar provisions. Each note and mortgage must be read and enforced according to its terms. This is important because the Kansas Uniform Commercial Code 84-3-108 subparagraph C states that an instrument or promissory note may contain a fixed payment schedule and be payable on demand, which is the type of promissory note that we have in this case. Payments are due according to
Mr. Schultz, let me jump to the very end of this, and let's assume we find that you're absolutely right, that the cause of action accrued in 06, that the provision in the promissory note about waiving the statute is void under Kansas law. We wind up then either dismissing the case or sending it back to the district court to dismiss it, right?
Correct.
Okay. If that happens, is the bank then in a position where it can simply find another default, send another notice, and we're back to square one in a new case?
Judge, the delay, I missed a little bit of your question.
Okay. My question is, assuming we dismiss this because the statute of limitations is run, okay?
Correct.
Right. The note itself actually continues through 2025. Is the bank in a position to declare another default and start this process over again next week?
No, because 84-3-108C makes clear that notes can contain both a payment schedule and be payable on demand. And according to that statute, such notes are due according to the payment schedule unless demand is made, in which case the payment schedule is then modified to be according to the demand. So once the bank made a demand that all of the amounts are due and owing, the remaining payment schedule is irrelevant because the bank has exercised its right under the note to declare the entire amount then due.
So your folks then basically would get 300 some thousand free dollars. Is that what you're saying?
I am, Judge, and equitable considerations on the statute of limitations do not apply outside of deception or fraud. And in the case of Dunn versus Dunn is 47 Canap 2nd 619, did an exhaustive review of the use of equitable doctrines to bar statute of limitation defenses. I would point out to the court that this was not raised below by the plaintiff, has not been briefed, is therefore waived. But even without that, there is nothing in the record to indicate that there's any deception or fraud on the part of my client, which would be necessary to use an equitable doctrine to bar the statute of limitations.
Well, I'm not necessarily going for the equitable doctrine. I'm going for why are we disregarding the remedies upon default that obviously gave them, quote, at the lender's option, whether to accelerate and when to proceed on a commercial note that clearly on its face does not mature until October 28th, 2025. Why should we disregard what your clients as commercial lenders or borrowers agreed to?
Judge, because that they agreed that the bank had the right to send demand and demand that this note was payable on demand. And once the entire note was called, once all amounts were due and payable, the bank had the right to foreclose on all of the amounts. I think the case of Rex versus Warner, when it lays out the true test for when a cause of action accrues, applies in this case because the bank could have foreclosed the entire amounts due. They
could have, but they had the option not to by contract. Is that correct?
That is true, but when they exercise their rights under that payable on demand feature, that was one of the rights that the bank held under the note.
Why is FGB Realty Advisors not applicable in this case?
For two reasons, Judge. The first is that dealt with an acceleration clause, and the bank here exercised their rights under the payable on demand feature.
Well, they accelerated, and it says there's no magic language. It says that both in that case, it says the Supreme Court said that in Foundation's property investments, there's no magic language. They clearly accelerated. The maturity date is 2025. So whether we call this a partial payable on demand and a option to accelerate, they obviously accelerated. If not, Judge Atchison just gave us the answer to the case, then we have until 2025 to worry about this. And they obviously accelerated. Are you saying they didn't accelerate?
No, that is not what I'm saying, Judge. I'm saying that this promissory note had both a acceleration clause and a payable on demand feature. But you also have to examine the acceleration clauses in each contract. The FGB Realtors Inc. case also contained a paragraph where that court quoted from a prior case that stated you have to read each acceleration clause for the terms because these are simply contracts. And
if I read this on its face, they had the option to accelerate. They had the option whether to file a lawsuit or not file a lawsuit. On its face. Seems like you want us to go off its face and try to rely on a UCC provision that may or may not be applicable in this case.
No, Judge, I think that you have to read the note from the clearly on the face of the note, which states that it is a payable on demand note, and which when demand is filed, you have to comply with that demand or you're in default of all of the payments that are due.
Isn't that by definition acceleration? Instead of allowing your people to have until 2025 to pay it off, they're saying you have to pay it off now. That seems to me to be the definition of acceleration.
I would agree that the bank did accelerate the note. Whether you call that an acceleration or a payable on demand, I think that if the bank had not sent a demand for payment in full within 10 days, they could have waited until the last payment was missed in 2025.
Well, doesn't
But because they
FGB say that? Didn't that happen in FGB where they sent out a demand letter and then they didn't file a lawsuit until later?
That is correct. They did. They sent a demand letter with the notice of the right to cure. But in FGB, that is a commercial or a consumer note that contains what I typically call a Fannie Mae or Freddie Mac secondary guarantees or consumer protections for notes and mortgages to be sold on the secondary market. Because in that case, the acceleration also had to include the bank giving notice that specified the default, the action required to cure the default, the date for which it must be cured, notice that a failure to cure the default may result in acceleration, inform the borrower of the right to reinstate, and inform the borrower of the right to assert in the foreclosure proceeding the non-existence of a default or any defense to acceleration and foreclosure.
So here we don't have, just so it's clear, we're not dealing with the consumer loan. So we're dealing with business owners. It looks as if your clients own some type of gas or oil company and they gave security agreement on car wash equipment. So aren't we dealing with two commercial entities here?
Yes, we are. And that's why
so we should treat them with as on equal terms as far as their ability to bargain for the terms of the agreement. Is that correct?
I would agree with that. Yes.
Okay. So why do they not have the right to have your clients knowingly waive the statute of limitations to the extent allowable by law?
Could you say that again, Judge? I'm sorry.
Why should we not apply then, with considering your guys are commercial borrowers, why should we not enforce their waiver of the statute of limitations to the extent allowed by law?
I believe that the appellate courts of the state have been clear that statute of limitations waivers are void against.
How are they? What case has been clear that says that? Are you talking about the 1924 case that says you can't waive it altogether? You cannot completely waive the statute of limitations? I don't know of any case that says you can't reasonably waive the statute of limitations if you have parties of equal bargaining power. But if you know of a case, cite it to us.
I believe that was a 1924 case, yes, Judge, that stated that agreements in advance to waive statute of limitations altogether are held
altogether. Agreements to completely waive altogether. Here, they didn't altogether. Your clients didn't altogether waive this, completely waive it. They waived it to the extent allowable by law. And hasn't our Kansas Supreme Court in the Gideon case enforced an extension or a waiver of the statute of limitations? Now, in that case, it was a debate over what day the statute ran, but they certainly found that provision to be enforceable in Gideon, it seems.
I must apologize, Judge. I'm not up to speed on that case.
Okay.
You're about to go into your rebuttal time. Before you do, I wanted to ask one other question about a what if here. Can the bank withdraw its demand? I mean, the note hasn't expired yet. Can it just simply withdraw the demand that it made in 2006?
I don't believe they can, Judge, for statute of limitations purposes.
Well, any purpose. I mean, the note, go ahead.
I think that once there's been a demand, then my client had a duty to comply with that demand. And once my client did not comply with that, then the bank had the duty to enforce its rights in a timely manner.
Okay. You are at the end of your opening time. You have 3 minutes for rebuttal. We'll hear from Mr. Dodge now. Whenever you're ready.
Thank you, Your Honor. Judge, in this case, I think the primary consideration for the court should be to resort to reviewing that acceleration clause that we've been talking about here. In that FGB case that we've been discussing, in a case where you've got an acceleration clause, that is the determining factor on whether or not, for purposes of statute of limitations determinations, whether or not the time is commenced or not. And in this case, in that FGB case, which I think is very similar to the one we have here, numerous demand letters were sent by the bank, requests to pay, right to cure, however you want to call it, asking for payments to be made, for the loan to be made right. But under that FGB case, the requirement is more than just a demand has to be made. There has to be some sort of overt action, some affirmative action taken towards the enforcement of that option.
Under that rule, what do you consider to be the additional action that would cause the breach of contract claim to accrue?
Well, Judge, I think one would be hiring of an attorney. That would definitely be a step towards that direction. The other clearly would be filing a lawsuit in which you ask for the acceleration terms to be applied. Those are two of the most clear-cut reasons. And I think requiring that makes a whole lot of sense. This is a decision, this procedure in our Kansas law has gone back at least till 1904, over 100 years, where we require some, that even though it may be a payable on-demand note, when there is a term which allows for acceleration, we use that as the requirement. And in the FGB case, they refer to a case called from Iowa as for support, the Wentland versus Stewart case. And in that case, the court mentioned that the acceleration provision clause is a shield for the lender. It shouldn't be utilized as a sword. And so defendants in this case want to say that if you send that demand letter, that allows you all the resources in that acceleration clause, essentially. And so under the terms of this note, Judge, I mean, under that reasoning, if all it was required would be to send a letter and nothing more, then the bank could have, as Judge Bruns indicated, go and collect on the collateral that was to the car washing equipment, just gone and taken it. They could have raised the interest in the promissory note to 21% as allowed by the terms of the note. And that's not the intent of that acceleration clause. It shouldn't be utilized as a means to put the screws to a borrower. You know, for example, if a car wash is making money hand over fist, or a bank loaned it to a business who they could tell was making tons of money, and they kind of second guess their interest rate. They're like, hey, wait, we ought to be able to charge more interest because this guy's making tons of money and we're only getting 7% or we're only getting 5%. We'll just send a demand letter and move the interest rate up and not do anything else to enforce that. Well, that puts the borrower in a tough spot. And that's why the court has required, for at least over 100 years, some affirmative step towards that. And so, Judge, that's why I think that the clearest indication would be hiring an attorney, or, and FGB refers to this, and I wish we had the actual demand letter in that case and in front of us, Judge, but there was a clear and unequivocal use of or claim that they were going to use the acceleration clause. I think even on page 854 of the opinion, they made it clear that they were exercising their option under the note to accelerate. None of that occurred here. We've got demand languages for payment and for unpaid principal, unpaid interest, but we don't have a specific engagement of that acceleration clause.
Let me pose to you the same question I posed to Mr. Schultz. If in the greater scheme of things, we decide that he's correct, that the cause of action accrued in 06, and the waiver of the statute of limitations provision is void, he gets a judgment for his client in this case. Do you share his view that the bank has no further remedies whatsoever, and in Judge Bruns's assessment, his clients get the $325,000 free and clear at this point?
Well, that would be the result. I think if the court determines that the statute of limitations, and make sure I understand right, was applicable and that it's sent back.
Well, basically, he wins this case.
I think if you determine that, Judge, I'm sorry, I didn't mean to interrupt.
Yeah, go ahead. No, I mean, if he wins, is the bank completely out of luck here?
Well, I guess it would determine, we filed the lawsuit back in 2014. And so under my position would be that, if there's an acceleration clause, that would be the date that the clock was ticking, and now we're at 2020. So we would be.
No, I understand that. I'm assuming that away and saying if he wins this lawsuit, you still have a note by its terms that is extant till 2025. Does the bank have some other relief or remedy at that point,
I think,
or any point between now and then?
In each of this promissory note is kind of unique in the sense that it talks about interest-only payments, I believe, beginning in July of 2005, for interest-only payments, and then principal payments beginning, or it doesn't say principal, but then payments of a certain dollar amount beginning in November of 2005. But it does 240 payments. It doesn't give a specific time frame. I think that an argument definitely could be made, Judge, that each and every one of those missed payments creates a new obligation, and that we could theoretically proceed again with the lawsuit, starting this whole trip over again.
If you
Which
do
you'd
that,
rather not do,
though,
obviously. But
I'd rather not. Yes, sir.
if you did that, though, it seems like you'd still run into potential statute of limitations problems if we didn't address that, because they didn't make any of those 240 payments.
They did. Yeah, absolutely. They did nothing. I think the argument would be, there's no real, there's a little bit of ambiguity as to those 240 payments. Are they monthly payments? Could they have waited and made 240 monthly payments, weekly payments, 240?
Or could they wait
right
till
before
October 27th, 2025 and make
247 payments? Right. I mean, that would be the other argument there.
So tell me, is it your position that the waiver of the statute of limitations provision, to the extent allowed by law in the commercial note, is somehow void based on old case law, or what's your position on that?
Judge, my position is similar to what questions that you asked Mr. Schultz, in the sense that we have two sophisticated business parties operating at arm's length negotiations that have entered into an agreement for a substantially large amount of money. Each have had the opportunity to have counsel and provide them the ins and outs of.
Do we know if they did? You can finish your answer, but just so I think about it, do we know if the parties were represented by counsel during this?
I know that the bank was not. They had the opportunity to be represented by counsel. I guess I should say that. Judge,
so both sides had the opportunity. You don't know whether they did or didn't.
Well, I know in the case of First Security Bank, an affidavit was filed in the district court case stating they had not hired any attorney until my firm was hired in 2014. Okay. I can't speak.
Well, go ahead and complete your answer about the waiver. I interrupted you. Sorry.
So I think if it's a reasonable waiver, and in this case, we're dealing with a note of 20 some years with 240 payments. We're dealing with a business entity. We're dealing with not all rights are being waived, but a specific right of limitation as it's allowed by law. Understanding there's also this acceleration clause, and having this acceleration clause, I think is important to understand. Is there's a lot of points made by defendant that this is a payable.
Wait, hold on just a second.
Yeah.
It looks like Mr. Schultz dropped off.
Yeah,
we
we
need to get him
lost
back
Mr.
on.
Schultz.
We need to get him back on before you continue your argument.
Yeah, that might be fair.
Yeah.
Let me inquire of our technical folks here. Have we lost Mr. Schultz, and are we trying to get him back?
Have we? Here he comes.
There
he
we
is.
go.
Oh, there he is.
All right. Have we got you now, Mr. Schultz? Can you hear us?
Yes, I can. I apologize. My internet at the house or at the office quit.
I understand. When we stopped talking, we just told royal stories or something. I don't know.
It didn't take very long.
Yeah. I think we were in the midst of an answer about, were we still on the
A waiver
validity
of the
of the
statute of
waiver?
limitation.
Yeah.
What would be reasonably allowed by law when it says to the extent it allowed by law?
And go ahead, Mr. Dodge.
Well, Judge, and I think it would be reasonable to allow a waiver of statute of limitations, especially in the case of a 20-year note where you have an optional default provision. It clearly anticipates that the parties understand that there may be, I don't say clearly anticipate, the contract provides, in the eventualities that a market turns down or that some unforeseen pandemic appears, that maybe that we need to not necessarily start foreclosing notes simply because of a missed payment. And that's the benefit of this acceleration clause. It gave them the option, and the further benefit to the borrower and to and as far as clarity to lenders would be requirement that there be some affirmative act where you can point to and say, yes, this is the time when they specifically made it clear to the lender that they are exercising their rights under the acceleration clause.
Is it your position, and I don't want to put words in your mouth, but you use this phrase that the waiver is for a reasonable time, or it's a reasonable waiver, as opposed to one that is an absolute waiver or one in perpetuity, such that the bank could have waited 20 years to bring the action?
Well, I think you have to look at the four corners of the contract entirely and try to ascertain from that what was intended. If it was a completely, we are waiving all statute of limitations for any and all reasons, that would be brought into question. But if it was, reasonably related to what was going on in the contract, then I think, yes, we could have waited until 2025 if there were reasons to wait.
Well, you could have waited till 2030, perhaps, depending on the scenario.
Yes.
5 years after the maturity date, depending on the scenario.
Right.
As a practical matter, go ahead.
Mr. Dodge, is there anything in the record as to why the bank waited 8 years, or is the record silent on that?
The record's silent on that. Mr. Schultz, I'm sure will correct me if I'm wrong, but my recollection is that they just didn't do it. They had, I can tell you reasons off the record, Judge, but there's nothing
Well, no, I mean, we're confined to the record, so. All right. You still have about 5 minutes, I think,
Well,
if you would.
And Judge, I really think the FGB case is really controlling in this case. And I think that notwithstanding defendants' insistence that this payable on demand feature makes a big difference, when there's an acceleration clause, I think that's the determination of statute of limitations. The payable on demand just, kind of states, could the lender ask for the full amount to be paid, or could just say, hey, it needs to be paid now. But when you take into consideration all of the terms of this note, none of the parties, I don't think, when they signed this contract would believe that the bank could take a note 1 month and turn around the next month and say it's all due now. Because of that acceleration provision, that's the provision that determines, was there a default? Could they've accelerated the whole amount due? Those sorts of things. So, Judge, I guess in closing, I would say it's our position that there has to be a demand made and a statement that we are going to use our accelerated rights under the contract, and then an affirmative step to carry that out. I think that's the sole issue for today.
Was the affirmative step here the actual filing of the lawsuit?
That's my belief, Judge. I think that, if the court's looking for, that would be clearly the time where the buyer was put on note, or the borrower was put on notice that they were exercising their rights.
To me, that seems like sort of a peculiar rule, is that you're saying the conduct that triggers the time to file the lawsuit is the filing of the lawsuit.
Well, and I can understand that, Judge, and that may be a fact issue that's determined in each and every case. That, in the case of a tort, if someone gets or maybe injured by medical malpractice, they may not find out that there was negligence for 4 or 5 years later. Or in the case of, a fraud, they may not learn, until 10 years after the fact. And those are things that would be developed through discovery. I would say.
Is there something in the record to confirm when the bank first retained your firm?
Judge, there was an affidavit filed by Tommy Sleeper, who was president of the bank, who stated under oath that the first time any counselor was hired was in 2014 to collect on this debt.
And that is part of the record, was attached to the summary judgment motion or the memorandum?
I think I can pull that up here. I believe it's on page 180 in volume 1.
Okay, thank you. Well, speaking of that, are the demand letters in the record? I haven't seen the demand letters because I haven't really looked for them, but are they in the record?
In my motion for, or my brief in support of summary judgment motion, I think I attached like 30 some letters that were part of that. And I think Mr. Schultz also attached one to his motion as well.
It's your position, though, that the acceleration, no mention of the acceleration clause in any of those letters.
There's no mention of the acceleration clause.
Anything further, Mr. Dodge?
No, Your Honor. Thank you.
All right, thank you. Mr. Schultz, you have 3 minutes.
Can you hear me now?
Yes.
Yes.
Okay. Thank you, Your Honor. If you look at the specific acceleration clause in this case, it states that the bank can, without notice or demand, accelerate the note by doing any one of the following things. And one of those things is to declare that all sums are due and payable. I struggle to understand how a demand, which states that all amounts are due and payable, unpaid principal, interest, and penalties are due within 10 days, is not a declaration under the acceleration clause. I don't think that there are magic words or magic phrases that have to be used in order for the bank to exercise its right. And I go back again to the fact that if the bank had never sent a demand on this case and exercised its right under either the payable on demand feature or the acceleration clause, then my client did not have a duty to make payments except as according to the payment schedule. And if my client did not have a duty to do that, then there hadn't been a breach and the bank wouldn't be allowed to file suit to foreclose the entire amounts due. But the bank did exercise their rights by declaring and demanding everything was due and payable within 10 days. When my client failed to do that, the bank was well within their right to file suit and foreclose to collect all of the amounts that were due and payable under the note. And the Rex versus Warner case is very clear that when you have a right to go file suit to pursue your cause of action, that is when the statute of limitations begins to accrue. And the position put forward by the bank as held by the district court, that until an attorney is hired or until a lawsuit is filed, the statute of limitations doesn't begin to run, is nonsensical. The statute could never run on a bank absent legal malpractice after they had hired a lawyer. It doesn't matter what actions that they took, as long as they didn't hire a lawyer, they could collect on those forever under an acceleration clause. And I don't think that is the law. They talk about affirmative acts. Well, affirmative acts is something that the bank did. What action did they take? They sent a declaration or a demand that said all amounts are due and owing within 10 days.
Mr. Schultz, it would be your position that, which might benefit your client, but it seems like would hurt debtors across the state of Kansas. Your position would be that it would force banks to immediately file a lawsuit against debtors instead of giving them any grace after they've sent that demand. Because once they've sent that demand, you say the clock starts ticking. It's kind of like, I'm a basketball fan. It's kind of like the referees counting off the 10 seconds to get across the court. And so it would force banks to sue borrowers, wouldn't it, under your scenario? And is that against public policy?
No, I don't believe so, Judge, because you have to look at each specific promissory note to look at the provisions that apply.
Well, this is a very typical promise. I mean, this is a very standard commercial note that's used by, or at least was used by bankers across the state of Kansas, isn't it? I mean, this isn't some contract that is just has special unique language that relates to your two clients.
I agree that it is a standard form note. I do think it's actually an Oklahoma form note, but I don't think that's relevant here. But Judge, they still have 5 years. They just don't have 8. And the public policy of the state is to prevent stale claims. In this case, my client received a demand and had this ground for 8 years before the sheriff showed up to serve him.
So if your clients would have made a payment, let's say not within the 10 days, because you said that's when the statute started to run. Let's say they made a payment about a month or two later. Would the bank still have had to sue within those 5 years, even though now your clients, they've given you some grace and your clients are trying to get back on schedule, which I don't think they ever even made an attempt to get on schedule, but that's neither here nor there.
Well, I believe the payment extends, the statute of limitations is extended from the last payment. So that would extend it, that payment would.
But you're saying they already accelerated it. They've already called it completely. It's no longer a monthly payments, because under your scenario, it's now become a payable on demand. They've demanded that your clients owe the whole $300 and some thousand at that point. I mean, that's where I think your position, although good for your clients, and I admire that, is bad for debtors and consumers, and well, yeah, I guess not consumers, but commercial lenders throughout the state of Kansas, because it forces banks under your scenario to go ahead and file a lawsuit once they've demanded the full payment.
Well, again, Judge, I think they have 5 years, and I'm not aware of any bank that's waited 8 years without a payment to file suit. I don't think that would have any effect on commercial banking.
No, it would have an effect on debtors who would be sued even when they were trying to do the right thing and get caught up.
Well, again, I think that the statutes are clear that payments made restarts the statute of limitations or extends the statute of limitations. So a lender could still work with that debtor to allow them to make payments.
Could they then waive the statute, by agreement, waive the statute of limitations to the extent allowed by law?
I don't believe that they could.
Well, have you looked at this Gideon case at all? When exactly that was done in a case and the Supreme Court didn't say anything, it just, I don't, it's obvious. Let me tell you the sites just so you know. Barnes versus Gideon, 224 Can 6, where a contractual agreement to extend a statute of limitations was enforced by the Kansas Supreme Court. Now, I recognize it was not dealing with this specific issue, but I think that goes hand in hand with the case you're citing to us from 1924 that says that you can't waive the statute of limitations altogether. And it seems to me that you can raise it in a commercial setting to an extent that's reasonable. But I take it you disagree with that.
Judge, again, I'm not prepared to talk about that case.
We'll talk about the 24 case that says specifically that you cannot waive statutes of limitations altogether. Should we just take the word altogether out of there and say it's carte blanche? You can never waive the statute of limitations. I mean, it's done in criminal cases. It's done in civil litigations. It's done a lot to the extent allowed by law.
Well, I have I guess I'm having a hard time distinguishing between what the terms altogether and as allowed by law, how they would apply in a case such as this.
Well, would you agree to me that altogether means completely, that you are not allowed to waive the statute of limitations in advance completely, altogether? Would you agree with that part?
I do agree with that, yes.
Okay. And so that seems to me it at least leaves some room for negotiation between sophisticated consumer or a commercial party, excuse me.
I just am not seeing any limiting factor on what the waiver of a statute of limitations in a commercial note could be.
Have you looked at any cases from other jurisdictions that allow reasonable waivers of the statute of limitations? For example, up to the maturity date, for example, 5 years after the maturity date, Have you looked at any of those cases?
No, sir.
Okay. But you do understand that altogether has a meaning, and it doesn't mean that you can never ever waive it. It just means that you can't completely waive it. You do agree with that much, anyway.
I would have to, I guess the short answer.
Well, you don't
probably
have to answer that. I don't want to put you on the spot. Don't, if you want to answer that, answer that. If not, but you would agree to me that the word altogether must mean something, or it wouldn't be in that what you cite, because you're the one who cited it to us, and I'm quite thankful you did in your reply brief.
Yes, Judge. And if I may expand on this, I think the purpose of that waiver is so that if the first payment, is missed in 2010, and he's behind one payment, and you foreclose in 2020 because the bank is allowing the schedule of payments to be made, that's to prevent you from not being able to collect on that 2010 payment that was missed. But
right, it's to protect both parties. Ultimately, it could, depending on the scenario.
correct. But in this case, all of the amounts were due and payable in 2006. There were no future payments or future actions required by the parties other than my client to make payment in full. So I think that is the distinguishing factor there on that waiver of the statute of limitations issue.
Okay. Thank you.
All right. You've got an extended amount of rebuttal time to satisfy Judge Bruns's curiosity. So, we have concluded our time on the case. We will take it under advisement and get out an opinion as soon as we can. And that concludes our oral argument session today. We had two other cases that mysteriously disappeared before today, and we're thankful for that. But we enjoyed the argument. We appreciate the briefs. It's posing some rather interesting questions, and we will dig into them and get you an answer. And with that, I will adjourn our session today. Thank you.
Thank you, Your Honor.
Thank you both.